proposed exhibit by the defendant of various steps. I understand that Mr. Sullivan, you agreed to just play those ones that have been, or just moved it, admit those ones that have been played in court.
Yes, Your Honor. That's correct. Not the whole version.
Any objections?
Which one except for we discussed. There's one exhibit, and I think most of it's been played out between the two sides. No, it's 231, Sway in the Morning. If you want, I can put on the record the exhibit numbers we're taking off from earlier this morning. Okay, no, just to be clear on this. So, for the record, I'm reading the defendant's exhibit numbers that we are not putting in the full exhibit for, but we'll continue to put in the clips with the letters that I read during this morning's session. We will remove defendant's exhibit number 306.
What about the
We're keeping, that's why I said we'll keep the clips, which are 306A and 306B.
Okay.
We're removing defendant's exhibit 309, but keeping the clips A and B. Removing defendant's exhibit 229, but keeping clip A. So the record is clear, we're keeping defendant's exhibit 231 along with the clips which are labeled A, B, C, and D. We're removing defendant's exhibit 230, keeping clip A. Removing defendant's exhibit 214, keeping clips C and D in the David. Removing defendant's exhibit 302, but keeping clips A, B, F, and G. Removing defendant's exhibit 270, by keeping clips A, B, C, and D. Removing clip 269. Removing the defendant's exhibit 269 by keeping clips D and E. Removing defendant's exhibit 254 by keeping clips A, C, and D. Removing defendant's exhibit 242 by keeping clips A, C, and D. Removing defendant's exhibit 299 by keeping clips A, B, and E. I believe that's all of the corrections. And we're doing with this with the understanding that plaintiff's counsel in their closing will not suggest that any of the broadcasts are incomplete, that we were suggesting anything was not included.
So do you have other DVDs without a full DVD on it to give to Mr. Hall?
We'll have to, that's far enough. We'll have it.
You mean you'll do it this afternoon for now?
We'll bring it to court tomorrow. The other issue here that I think we had raised earlier in the bench was concerning a composite exhibit, which was defendant's exhibit 829. They're based on earlier rulings in the case. There's a couple of small redactions that we're going to be making to that document overnight in agreement with the plaintiff's counsel, and we'll bring a new composite exhibit with those minor redactions.
Any others have any objections to?
No, Your Honor.
So all of those, other than the ones just articulated by Mr. Berry, the plaintiff has no objection. Those are the ones that were moved in earlier, early this morning.
Correct.
Okay, so the point will receive 306 A and B, not 306. 309 A and B, not 309. 229A, 231 A, B, C, and D. Mr. Berry?
Yes, 31 A, B, C, and D.
230A, but not 230. 214 C and D, but not 214. 160, 215, 165, 57, 76, 302 A, D, F, G, but not 302. 270 A, B, C, D, but not 270. 269 D and E, but not 269. 254 A, C, and D, but not 254. 68, 70, 242 A, C, D, not 242. 299 A, B, E, not 299. 75, 413, 515, 514, 112, 266B, 110, 197, 196, 877, 120, 136, 137, 138, 132, 124, 125, 127, 128, 130, 541, 77, 364, 365, 565, 139, 140, 141, 874, 566, 342, 362, 153, 155, 88, 90, 574, 58, 59, and 232A. Is that correct, Ms. Nathan? Do you have Mr. Berry?
Yes, Your Honor, and then tomorrow we'll bring
829. So tomorrow morning we'll deal with 829 before I receive that. Okay? Now, to the point of plaintiff activity in D311.
But in defendants,
I'm sorry.
I should say plaintiff, just misspoke.
D. I have D.
You said the plaintiffs who were D311.
Okay, so the defendants moved in D311. This morning, it was, I have not seen D311. I had seen one that was the same. During this break, I've had the opportunity to review D311 with the tape, the DVD that I previously reviewed. They are not the same DVD. The other one that I had reviewed before had been edited, which was one of the issues as to why I reviewed multiple versions of the same DVD, which, in light of that information, then, the court is going to sustain the objection on D311 on authenticity. Again, the reliability of it is questionable. It is not related to the controlling issue at hand of the excerpts that were published on Gawker, and it's not related or relevant to the defenses of newsworthiness or matter of public concern. Okay, anyone have any questions as to that particular ruling?
I think the ruling is clear.
Thank you. So you can have these 10 DVDs back, and you can have this one All right, anything else? Any other?
We had a motion for preservation. Judge, briefly, on a more tennis basis, I can approach. Judge, I'm going to hand you this copy. When Miss Libby was on the stand the other day, Mr. Budd, I believe, crossed her on a question of whether Gawker was advertising its live feed of this trial. There was an objection, etc. What we want to do is just, and I may have to let me go. It's not the statute. We want to properly at least make sure that no evidence is destroyed of any point in time that the live feed may have been taken down during that cross. I can explain further at the bench if the court wants as to why we're asking for that, but we believe that the feed was killed during some portion of that colloquy. after we asked to bring it up in court, that died on the bench while that was happening. We haven't correlated the time precisely yet. We have a pretty good idea that the feed was actually killed sometime in that area.
So I'm not clear on clarification on the breadth of the motion. Is the motion to preserve the entire live feed that Gawker has been doing in the trial, or just
during that period of time, during Ms. Libby's examination, any forensic data, digital footprints, or otherwise that would have indicated that Gawker was broadcasting live and running ads on that live feed at that time, we believe to the extent this case makes it to a punitive stage, it could be relevant at the punitive stage.
so that would have been the testimony on March 15th. That was taken after lunch. So in to the afternoon of March 15th. Through the afternoon of March 15th.
The witness would have been me and Libby. The questioning would have occurred on cross. I think it's safe to say we would ask for a preservation of the whole examination from direct through cross, and ask that they not wipe out, destroy, otherwise erase, and preserve any digital footprint of the live feed and any ads running at that time to the extent we think it would be relevant at the punitive stage.
On this issue, I think I was in court, so I was on the bench with Your Honor, so I have no idea how much the live feed, but my understanding is the live feed cuts out when there are bench conferences. Is point one. The second thing is I simply have no idea whether it's technologically possible to preserve a web page in the past. And I don't, third, understand why any of this would be relevant to punitive liability. And Your Honor ruled that it wasn't relevant even to the line of questioning and cut it off.
Judge, again, I think what we're looking for is this. There should be a digital footprint if a live feed was intentionally taken down during that question. The questioning related to whether they were running ads. We were having this long discussion of traffic and ads, as the court knows. And notwithstanding the fact that we thought it was relevant, they objected. It's not going to the jury on the underlying case. But to the extent there's digital evidence of it and we hit a punitive stage, the fact remains that if there was an intentional cessation of the live feed to prevent a witness from actually confirming in court that they were running ads, it could go to punitive. We just don't want them to wipe any digital footprint off of what was done, if it was done intentionally. If there's some kind of technological glitch, I guess we can sort that out. It's just a very prophylactic measure, Judge.
Sounds reasonable.
Well, we'll do what we can. Your Honor, earlier in the case, you had entered a preservation order from the bench. And we had provided a proposed order to plaintiff's counsel and haven't heard that back yet. I'd like Your Honor to enter the order.
I'm not sure. I've read a number of preservation orders. I'm not sure which one you're talking about.
One directed to Mr. Houston.
Houston. That was submitted. I don't think we have an objection to formal content. It was to the David Houston issue about
preserving all communication with the plaintiff concerning the sex case from early March 2012.
So that was in the order that I had said during the trial?
Yes, Your Honor. At the bench.
You ordered at the bench. Well, a written order was submitted. We didn't have an objection to formal content. So I don't know where it's at in your set of orders. But
it wasn't submitted. As far as I know, we submitted it to plaintiff's counsel to submit. We haven't seen the copy since, Your Honor.
Maybe y'all can talk about it. It sounds like there's no objection, so there's somebody just hand it to me. Since we're all in here, it's a little bit difficult to be in here and doing other things at the same time. Okay? What else?
that's it for us, Judge.
All right. So then the ordinance motion to preserve the live feed during testimony of Neil Libby of 315 is granted. And we need a written order as to that, which I would think we do. Mr. Gawker can prepare that written order.
Your Honor, I'd like some clarification from plaintiff's counsel about what it is exactly that they want us to preserve. The live feed is not run by Gawker, it's by somebody else. The website is run, but I have no idea what exactly it is that they'd like us to hold on to, and at this point, I have no idea if this is possible.
Judge, I don't know that I can be more clear. There was a witness on the stand. They were talking about
I think
advertising.
it's already been discussed.
So-
It's decided, so I'm not going to require Mr. Turkel to articulate the exact technological terms. We want to say that it sounds as though it's going to the advertising that was done at the time. If there was any advertising at the time, I'm sure there was. Somebody got some screenshot of it that'll come up at some other time. But so any kinds of things that were run during that few hours, I'm saying that the defendants need to preserve that. And I understand that CBN does a live feed, so that may not technically be the correct version.
We'll figure out the verbiage and submit an order for their review, Judge.
Thank you.
Judge, I just want to point out to the board, in addition to the list of evidence that Mr. Barry read that moved in to confirm, previous to today, on the 11th, I believe, they moved in D310.
Okay, so that's not on the list. So we still.
I think that was actually kind of.
That's the excerpts, Your Honor, that were posted on the website. So they had a better quality version, so we moved that in during our case.
So that was, I suppose, important.
All right. So we're for the two reviewers. We're going to figure out the numbers later on.
That's the plaintiff. They're from the defense exhibit. The plaintiff gave me 2 CDs, or DVDs, and they are 617, 618, plaintiff 617, 618.
So is 310 one of those ones that was moved to a plaintiff's number?
No, we just used the defense version for consistency because it's the same on both. We did do excerpts from that. It's the actual video.
And so did the plaintiffs move it in?
Yes.
And was it received?
Yes, sir.
Okay, so plaintiffs moved it in, the court received, defendants 310 as plaintiffs.
We didn't renumber it. You can't renumber it.
We didn't renumber it just because no modifications were made to that one.
And there isn't another 310? By the defendants? No.
No, Your Honor. It was our understanding that they did that, and there was no issue at the time. It continues to be no issue.
Okay. I just want to make sure there's not 2 310s. So we're going to ask 2 310s. Okay, great. So plaintiffs moved into the 310 and then was received. Okay, great. Thank you. Mr. Hall. Anything else on the plaintiffs? Anything else on the defense?
I don't think we've fully wrapped up the verdict form issue, and I think it's just a matter of getting it to you, right?
Well, I know I have a number of copies this morning, and so at this point in time, let's confirm that your copy and my copy look the same, and then let's make sure that they are accepted on. Accept the verdict form and submit.
Preserve all prior to
Thank you. All right, so I think some extra copies. This is the one which is.
Yes.
Tomorrow morning at 9 o'clock, the defense can move in whatever other exhibits that they think is like 829, make sure that gets corrected. And any other exhibits over the course of the evening that you think somehow got forgotten. And then at that point, you finish the rest, right?
Yes, Your Honor. We will rush to that point. So I understand that the plaintiff might move in exhibits, and I would ask that they tell us if they are in advance so we can report some of the...
We'll have no delays tomorrow.
Exactly.
We're going to have whatever witnesses we're going from there. Are there going to be any rebuttal witnesses? No?
No.
All right, so then we'll go right to closing at that point. So we should be in closing, or at least be giving the jury instructions by 9 o'clock.
That's right.
Sure. Okay, so we're not going to have to delay like we did today. All right, anything else for today?
Nothing.
Okay, hopefully everybody will give a good next rest. Thank you all very much.